Mr. President.
Senator from Hawaii.
Mr. President, I ask unanimous consent that Ariel Castillo, a legislative fellow in my office, be permitted floor access for the remainder of the 115th Congress.
Without objection.
Mr. President, I thank my friend, the good senator from Florida, for speaking out on the critical importance of the Affordable Care Act for millions of people in our country and calling upon this administration to support health care for all instead of what they're doing to the health care of millions of people in our country. Mr. President, turning to another matter, nearly 12 years ago, on December 7th, 2006, President George W. Bush nominated Thomas Farr to be a U.S. District Court judge for the Eastern District of North Carolina. Today, 12 years and 3 nominations later, his name is again before us for confirmation to the very same vacancy, which has remained unfulfilled or unfilled all this time. When Mr. Farr was nominated for this vacancy in 2006 and 2007, his nomination did not receive a vote in the Judiciary Committee. It was known at that time that Mr. Farr had spent his professional life engaged in restricting minority voting rights and defending companies alleged to have discriminated against African Americans, women, and others. In the 1980s and in 1990, Mr. Farr represented Senator Jesse Helms, notorious for his opposition to civil rights, voting rights, women's rights, workers' rights, LGBTQ rights, in other words, individual rights. Mr. Farr also helped corporations fight off their employees' discrimination claims. In 2003, Mr. Farr defended Blue Cross Blue Shield of North Carolina against claims by a female employee who alleged that the company had compelled her to resign because of her sex and age. To win his case, Mr. Farr convinced the North Carolina Supreme Court to strike down the county's anti-discrimination law. Given this history of restricting minority voting rights and defending companies and discrimination claims, Mr. Farr's nomination did not proceed at that time, and rightly so. In the 12 years since his first nomination, Mr. Farr has become notorious for his defense of the North Carolina legislature's attempts to disenfranchise African American voters. His current nomination is opposed by nearly every civil rights group in North Carolina and nationally, and the Congressional Black Caucus, CBC, has fought Mr. Farr's nomination. In a 2017 letter to the Judiciary Committee, the CBC wrote, quote, "It is no exaggeration to say that had the White House deliberately sought to identify an attorney in North Carolina with a more hostile record on African American voting rights and workers' rights than Thomas Farr, it could hardly have done so," end quote. This district court vacancy was not filled by President Obama in his 2 terms, but not for lack of trying. President Obama nominated 2 different African American women for this vacancy, one an assistant U.S. attorney and another a state court judge. Neither nomination moved forward because the Republican home state senators withheld their blue slips. Judiciary Chairs Leahy and later Grassley both at that time abided by the blue slip process during that period, as I said, and no hearings were ever held for these 2 Obama nominees. At the same time, both of my colleagues from North Carolina persisted in their desire to confirm Mr. Farr to the federal bench. Of course, now, returning of a blue slip is no longer a barrier to pushing nominees through the Judiciary Committee. So, on the recommendation of my Senate colleagues from North Carolina, Donald Trump nominated Mr. Farr yet again to the seat that had been kept open in the Eastern District of North Carolina. In fact, when Mr. Farr's nomination was returned at the end of a session of Congress last year, the White House decided to re-nominate him this year. This history regarding this judicial vacancy and Mr. Farr is key to understanding why I and so many of my colleagues will vote no today. We will be accused of obstruction and of wanting to deprive the people of North Carolina of a judge in the Eastern District. We will hear how this is the longest open vacancy on the entire federal bench. But in fact, this vacancy has remained open so long because of Republicans' refusal to confirm qualified minority women and their insistence on filling this vacancy with a man whose career is filled with examples of his using the law to advance a racist, obstructionist, plainly un-American agenda. Had the Republicans not blocked the nominations of qualified minority women in 2013 and 2016, this district, which is about 27% African American, would have had its first African American judge. By contrast, Mr. Farr has spent decades opposing the rights of African Americans, women, and workers. Let me highlight a few examples. When Mr. Farr was working as legal counsel for the 1990 campaign for Senator Jesse Helms from North Carolina, the Justice Department filed a federal lawsuit against the campaign for trying to intimidate thousands of African Americans from voting. How did they do this? The Helms campaign sent postcards suggesting that the voters were ineligible to vote and warning that they could be prosecuted if they voted. Although Mr. Farr denied any involvement in these racist voter intimidation efforts, the Justice Department attorney who investigated the matter confirmed that Mr. Farr, quote, was certainly involved in the scheme as it was being developed, end quote. That was not the only time Mr. Farr has opposed the rights of African American voters. When the North Carolina legislature sought to restrict or dilute the votes of African Americans over the past 10 years, Mr. Farr fiercely defended these efforts as a private attorney. In 2013, for example, he defended the North Carolina legislature's voter suppression efforts that a court found were enacted with racially discriminatory intent. Racially discriminatory intent. In other words, the North Carolina legislature was totally upfront about what they were up to. After the Supreme Court effectively struck down the part of the Voting Rights Act that required North Carolina to pre-clear any changes to their voting laws, the North Carolina state legislature passed a law that eliminated or cut back on voting mechanisms that African Americans disproportionately used. This is a law that Mr. Farr defended. And the Fourth Circuit, in that case, determined that these voting changes, quote, targeted African Americans with almost surgical precision, end quote. In other words, blatantly discriminatory intent was found by the Fourth Circuit. Between his efforts to support suppression of minority voters, Mr. Farr has helped companies avoid accountability for discrimination against African Americans, women, and minority groups. In 2003, Mr. Farr argued that female employees at Pfizer were not protected under federal civil rights laws from condescending, sexist, and sexual comments from their manager because they were, in his view, not severe or pervasive enough. He even tried to undermine the plaintiff's claim by arguing that she failed to point out that her manager, quote, harassed her because of her gender on a daily or weekly basis. That was the standard he applied. You had to have been harassed on a daily or weekly basis. Mr. Farr ultimately convinced the court to dismiss the employee's claim as untimely. A person who has devoted decades of his legal career to furthering oppression and injustices against minorities and women has no business being confirmed to a lifetime position as a judge, where his ideological agenda will certainly be reflected in his decisions. I will not vote for Mr. Farr's nomination, and I urge my colleagues to do likewise. Mr. President, I'd also like to explain my opposition to another nominee being considered this week, Jonathan Kobus, for the 8th Circuit Court of Appeals from South Dakota. Mr. Kobus received a not qualified vote from a substantial majority of the ABA's Standing Committee on the Federal Judiciary. They reported that Kobus has, quote, neither the requisite experience nor evidence of his ability to fulfill the scholarly writing required of a United States Circuit Court judge. They continued, the Standing Committee had difficulty analyzing Mr. Kobus's professional competence because he was unable to provide sufficient writing samples of the caliber required to satisfy committee members that he was capable of doing the work of a United States Circuit Court judge, end quote. Hence their non-qualified vote for him. In normal times, this sort of negative evaluation from the ABA would be given to the White House before the White House decided to nominate someone, and the person would never even be nominated. But these are not normal times. Instead of following normal procedure, the White House has nominated someone profoundly unfit to serve for a lifetime on the Circuit Court, but who will nonetheless be confirmed on a party line vote. Mr. Kobus has demonstrated hostility toward women's reproductive rights. His anti-choice activism is on a par with so many other Trump nominees who are often relatively young, as he is, and profoundly inexperienced. In 2005, Mr. Kobus represented, as a volunteer, so-called crisis pregnancy centers, which were seeking to uphold the South Dakota law requiring doctors to inform women seeking abortions that, quote, the pregnant woman has an existing relationship with the unborn human being and that the relationship enjoys protection under the United States Constitution and under the laws of South Dakota, end quote. That is not the state of the law, by the way. Mr. Farr and Mr. Kobus are two of the worst of President Trump's judicial nominees, and that is saying a lot. They are two more examples of President Trump's relentless pursuit to pack the federal courts with ideologues who will rule in favor of conservative causes. Clearly, Donald Trump does not believe in the independent judiciary envisioned by the framers of our Constitution and respected by every president until now. We see in his single-minded efforts to pack the courts that he is nominating judges whom he believes will be his political allies. He tells us as much. He believes the judges he appoints are Trump judges and that they will be loyal to him and protect him and his policies when the time comes. Chief Justice John Roberts could not have been clearer in his response last week to Donald Trump's criticism of judges who don't rule his way. Chief Justice told the AP, quote, we do not have Obama judges or Trump judges, Bush judges or Clinton judges. What we have is an extraordinary group of dedicated judges doing their level best to do equal right to those appearing before them. That independent judiciary is something we should all be thankful for, end quote. The independence of the judiciary is not something that Donald Trump acknowledges, values, or even believes in. What he wants are Trump judges who will rule in favor of his policies and decisions and who will satisfy his ideologically conservative base. It is no wonder that Chief Justice Roberts felt it necessary to take the extraordinary step of reminding the president and the country that the judiciary must be independent. I urge my colleagues to vote against the nominations of Mr. Farr and Mr. Kobus. Mr. President, I yield the floor.